Have you ever thought about how major disagreements could be settled, outside of the usual courts, but still end up with a decision that's totally binding, legally sound? Imagine a really structured process built on very specific legal and ethical ideas. Well, today, that's what we're diving into, Islamic arbitration. And our main guide here is this key document, Sharia Standard number 32, arbitration.
Yeah, our mission for this deep dive is really to kind of map out Islamic arbitration for you. We want to unpack the core ideas, look at the actual processes, and point out the nuances in the system, all based on the standard. It's not just a what is it, but really a how does it actually work kind of look, hopefully giving you a solid but manageable understanding.
And what's great about this source, I think, is how clearly it lays everything out.
Yeah.
The definitions, the guidelines. It makes it pretty straightforward to get a deep understanding without feeling, buried in information. Perfect for getting up to speed quickly and properly.
Okay.
Okay. So let's start with the definition. The standard kicks off by defining arbitration generally as an agreement of two or more parties to appoint someone to resolve a dispute between them with a binding judgment.
And that phrase, binding judgment, that's really important right off the bat. It tells you this isn't just like mediation where you hope people agree. No, this is formal. It leads to a definite outcome you have to follow, much like a court ruling.
Right. And then it gets specific. The document defines Islamic arbitration as a process where the rulings and principles of Islamic Sharia are applied. So this isn't just any arbitration. It's explicitly linked to that specific legal and ethical framework.
Exactly. And if you zoom out a bit, you see the foundation here is Sharia law. That's the core legal system being used, which gives Islamic arbitration a very distinct feel compared to other kinds you might know because it's rooted in those specific religious precepts.
Okay, so we've got the what. Now, how about the how? How do people actually get into this process according to the standard? It seems like there are a few routes.
That's right. First, it can just be by agreement, like a dispute pops up and the parties say, okay, let's use arbitration. Or second, it could be because of a prior agreement. Maybe it was in the original contract, a clause saying any future disputes go to arbitration, not court.
Right, like an arbitration clause.
Yeah.
And you mentioned a third way. Sometimes it's not even by choice.
Yeah, the standard mentions it can sometimes happen by legal obligation.
So, like, the law might require it for certain kinds of disputes.
Precisely. Maybe in certain industries or specific legal areas, arbitration might be mandated. It's an interesting way the system can be integrated even before the parties themselves think about it.
That is interesting. Okay, what about the parties involved? Who can actually participate?
The standard keeps it simple. The parties are the disputants seeking arbitration. And importantly, it says they can be more than two.
So multi-party disputes are covered? That's practical.
Definitely. Good for complex situations.
And is it generally allowed? I mean, between different types of parties?
Yes, it seems quite broad. The document says it's legitimate whether it's between two natural persons, two legal entities, or between a legal entity and a natural person. So individuals, companies, or a mix.
Covers a lot of ground then.
It does. But there's a key point about making it obligatory. The standard emphasizes that it must be explicitly stated that recourse to Islamic arbitration is obligatory in agreements where you could choose other methods. And crucially, it can't contradict existing laws. So that intention needs to be crystal clear from the start and compliant.
That binding aspect seems really central. The document says arbitration is binding if it's stipulated in the contract initially or if they agree later and committed not to revoke it. That sounds very final.
It is very final. And this leads nicely into the arbitrator's status, which has some interesting details. The standard makes a distinction. If an arbitrator isn't getting paid doing it voluntarily, they can recuse themselves after accepting.
Okay, they can step down.
Right. But if they're getting paid, their role becomes binding. And get this, if they step down then, and this causes damage, they actually have to bear the amount of the damage.
Wow, really? So they could be financially liable if they back out after agreeing to be paid.
Exactly. It's a significant point about responsibility. It's not just about refunding fees, maybe. It creates a strong incentive for them to see it through, which builds confidence in the process for the parties.
That is a huge detail. What kind of damages are we talking about usually? Financial losses?
Typically, yes. It would likely cover direct financial losses the parties face because the arbitrator withdrew things like extra legal costs, delays causing financial harm, that sort of thing.
Okay, that makes sense. So shifting from the person to the paperwork, let's look at the arbitration contract. The source calls the formulation, or alsia, a pillar of the contract. It defines it as the exchange of offer and acceptance between the arbitration requesters and the arbitrator. Why is that considered a pillar? What makes it so foundational?
Well, it's not just ticking a box. It's the core agreement, the mutual understanding that legally binds everyone involved, the parties and the arbitrator. Without that clear offer and acceptance, the whole thing doesn't really stand up legally. It's the bedrock of its legitimacy.
Got it. So beyond that core formulation, what else needs to be in place for the contract to be valid?
Well, there are key conditions. Things like the arbitrator's fees, if there are any, need to be clear. And here's something important. An arbitration clause, that's shart al-takim, if that's included in any contract, it acts as that commitment to use arbitration later. It can even take the place of needing a whole separate agreement when a dispute arises.
So that clause itself is powerful.
Very. And critically, the arbitrator has to apply the rulings of Islamic Shari'ah. Always. And they must make sure their rulings do not contradict Shari'ah rulings, even if they're also working within the constraints of a specific national law. The Shari'ah adherence is paramount.
So it sounds like the parties have some leeway to shape the process, too. The standard mentions they can restrict the arbitration with any legitimate condition that has a valid purpose for them.
Yes, they can tailor it to some extent. Gives them a degree of control. And interestingly, the arbitrator isn't necessarily bound by what experts say.
Oh.
Yeah, it says they're not bound by experts' opinions, which gives them independence in their judgment. They can consult experts if needed, of course.
But the final call is theirs, based on Shari'ah.
Exactly. It prevents the arbitrator from just, rubber stamping an expert's view. It ensures the judgment is truly their application of the principles.
To preserve their authority. Okay, let's talk timing. What if things drag on? Is there a deadline?
Yes, there's a clear rule for that. If the agreed-upon period for issuing the ruling runs out and it hasn't been issued, the arbitrator is basically considered dismissed.
Dismissed. Just like that.
Unless both parties agree to give them more time. And that clock starts ticking when the arbitration document is signed by everyone and stops when the final decision is signed. It sets a clear time frame.
That seems important for keeping things moving.
Yeah.
What about the contract format itself? Does it have to be a formal, written document?
The standard says it can be oral and still be valid under Shari'ah.
Really? An oral agreement?
Yes, for individuals. But for institutions, it specifies it should be documented in writing.
Okay. A distinction there.
And it also mentions that having witnesses sign the document isn't strictly required, but it is preferable. So some flexibility, but leaning towards documentation, especially for organizations.
Practical. Now, how does the arbitrator actually figure things out? Gather evidence, make the decision. What tools do they have?
They have quite a bit at their disposal. It says the arbitrator can use all acceptable methods of judgment in the judiciary.
Like a judge would.
Pretty much. And they can request anything related to the dispute, whether that's asking for documents or taking oral or written statements. Broad powers there.
But presumably with limits, you mentioned earlier they have to follow certain principles.
Absolutely. There are clear boundaries. For instance, the arbitrator cannot rule based on personal knowledge.
So they can't just say, oh, I know this person. So.
No, exactly. It has to be based on the evidence presented. And generally, they cannot accept testimony rejected in the judiciary. So they're bound by established legal standards for evidence, too. It maintains objectivity.
Okay, so all the information's gathered, the arguments are heard, the arbitrator decides. How is that final decision actually recorded and issued? Does everyone need to be on board?
Well, the ideal scenario, according to the standard, is that the decision must be issued with the signature of all arbitrators.
Even if someone disagrees?
Yes, including any dissenters. They can actually note their disagreement, their reservations, or opposition right there on the decision.
Interesting. What if they can't get everyone to sign?
There's an alternative. It can be issued by a majority of arbitrators. But if that happens, there needs to be a statement explaining why the others didn't sign, and it has to be clear that everyone was aware the decision was being issued.
So transparency even in disagreement.
Precisely. It ensures accountability.
And what does that decision document actually contain? Is there a required format?
It's pretty comprehensive. It needs to include names of disputing parties and their identities addresses, naturally. Also, a summary of the dispute subject, parties' claims, and their supporting documents.
The basics of the case.
Right. Then, names of arbitrators, names of witnesses and experts consulted, and crucially, the reasons for the decision.
The justification.
Yes, that level of detail provides a complete record, which is vital, especially if you need to enforce it later.
Good point. And about enforcement. Is the arbitration decision automatically the final word, or does it sometimes need court approval?
The standard is pragmatic here. It says arbitration is not pursued if the decision cannot be enforced. So enforceability is key from the outset. And sometimes, yes, it may be necessary to refer to courts that adhere to Islamic rulings to grant executive power to the Shari'ah decision.
So it can loop back into the formal court system for that final push.
It can. It shows how it works alongside or sometimes connects back to the judicial system.
Okay, one more thing on the decision itself. Can an arbitrator ever, change their mind after issuing the judgment?
Generally, no. The rule is the arbitrator cannot revoke their judgment. It's meant to be final.
But is there any exception?
There is one specific one. If the arbitrator states they made a mistake, like a genuine error in applying Sharia or understanding the facts, they can cancel or amend it according to Sharia and what achieves justice.
Ah, so a narrow window for correction focused on justice and Sharia principles.
Exactly. It allows for fixing clear errors without undermining the finality of judgments in general.
Right. Now let's switch gears slightly and talk about the costs involved. Money matters. Is arbitration always free?
Not necessarily. The standard is clear. The arbitrator is entitled to a fee if not volunteering. Or, if they're not already employed in a role that covers this, like a judge assigned to it.
And how is that fee determined?
Transparency seems key. It says the fee must be announced in the arbitration terms or agreed upon in the arbitration document. So everyone knows up front, no hidden costs.
That's good. What about other expenses? Things like, say, travel for the arbitrator or fees for experts they consult. Who pays for those?
The agreement itself must specify who bears them. That's the starting point. But then there are default rules. If an expense comes up because just one party requested something specific, then that party bears them solely.
Makes sense. The requester pays.
Right. But for joint expenses, things needed for the process overall, they're usually divided among disputing parties.
Shared costs.
Shared costs, unless it's proven that one party acted in bad faith or harmful causation. In that case, they might get stuck with more of the costs.
Ah, so there's a fairness principle, but also consequences for bad behavior.
Exactly. It aims for an equitable split, but it's flexible. And of course, parties can always agree differently from the start. Maybe agree that the losing party pays all costs, or one party covers everything regardless. That's also allowed if agreed upon.
Okay, that covers the financial side pretty thoroughly.
Yeah.
So we've really taken a deep dive here into Sharia standard number 32, arbitration. We've looked at the definition, how you get into the process, the roles of everyone involved, the contract, the actual procedure step by step, and even the money side.
Yeah.
You should now have a really solid picture of how this particular system for resolving disputes is set up and how it works in practice.
Yeah, it's quite a comprehensive framework. What really stands out to you about how it tries to ensure justice, all within that specific religious and legal context?
Well, for me, and hopefully for you listening, the sheer level of detail is striking. The fact that Islamic arbitration has these specific guidelines from how binding the judgments are to how arbitrators must conduct themselves, the meticulous recording of decisions, it really says something profound, I think, about the commitment to justice within this system. It's a powerful reminder that these formal ways of settling disputes can be, and often are, deeply woven into cultural and religious principles. It's not just abstract law, it's lived practice. So here's something to think about. How might that core emphasis on sticking to Sharia principles affect what kinds of disputes are best suited for this type of arbitration? Especially when you compare it to maybe more secular legal systems we might be familiar with. Something to ponder.